It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like, how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my plant-loving co-host, Brett.
I do love plants. Alice, I like to eat plants and grow plants and walk on plants. I don't really know what else to do with plants.
Well, I couldn't think of what is a name for a plant lover. I didn't want to call you plant lady because you're not a plant lady.
Horticulturalist? I don't know.
One who is fascinated by the plants, because we're going to talk about someone who has an expertise in botany and how that relates to genealogy. Are you confused yet? Because we're going to walk you through it all, and at the end, it's not going to be any more clear, and that's the point of this episode.
There you go, Alice. You brought it together at the end.
It took a couple circles.
You know, as long as it comes around, you landed the plane, and that's all that matters. The plane didn't crash.
We were building the plane as we were landing it.
We were. But we got the gears down last minute. It's like in the Memphis Belle. You guys ever seen that movie? Like right before the plane hits the ground.
Oh, my goodness. Well, okay. So for those of you who have no idea what we're talking about, today we are talking about Idaho, because the Idaho quadruple murder it's actually always in the news. It's not just has been in the news. It's going to be in the news really up until this case is resolved, because it is a case that from the moment the four victims were brutally murdered, it has captured the nation's attention, and it will continue to capture all of our attention, because the defendant who is currently being charged with their murders we haven't seen someone like him in a long time. It is very unusual for someone to murder four people at one time, four people they did not know. And it seems to be premeditated and not something where you just randomly shoot into, say, a crowded hall. And the more we find out about Mr. Kohberger, the kind of stranger it is. And recently he's been in the news because his defense team has been incredibly active in filing lots of things on the docket. And every single filing, no matter how large it seems or small it seems, I think throws everyone in a tizzy, because they're afraid that it means the prosecution has a weak case. So we're here to talk about some of those filings, what they mean, what they don't mean, and why you shouldn't be up in arms every time you see a filing on a docket, and especially on this docket.
And I'll say this, different places, practice is different. Norms are different. Different lawyers do it different ways. This is one of the most litigious defense attorneys I think I've seen in a while. The amount of things that she's filing, and it reminds me of an old saying in the law, which is, if the facts are on your side, you pound the facts. If the law is on your side, you pound the law. And if neither's on the side, you pound the table. And there is a lot of table pounding going on in this case, and a lot of filings which are almost inexplicable for any other reason than just confusion and delay. And I'm not sure what the overarching theory of the defense is, what they're trying to accomplish, But when you look at these filings, and we're going to be talking specifically about some filings about DNA, but we're going to mention some of the other ones. It's hard to ascertain exactly what they're trying to do. I have seen filings like this before, but they had a purpose, and we'll talk about the purpose that they have. But I'm not sure what the defense team is doing here, and I think you guys, when we finish talking about this, will understand why this is so confusing.
And if you are confused, we're talking about, again, the Kohberger defense. And here is a tactic, and it's a real tactic, and it's a good tactic for the defense, is confusion. And so that might be what they're going for. And also, when you're early on in the case and you don't know exactly where you're going to go, except you know the law and the facts are not on your side, and maybe you have a defendant who is unwilling to plead, then what you do is you can throw spaghetti at the wall, see what theory kind of catches fire, and go with it. So it could be any of those things. It could be for pure confusion. It could also be testing all your different theories and seeing, what you guys, by you guys, I mean listeners, Reddit, media, they're reading the media, absolutely, and seeing what seems like a viable theory to go on, because guess what? This will go to jury trial if it goes all the way there. And the people who are watching the news and clicking on articles potentially are a jury pool. And it's kind of a test as to what gets people excited about the defense.
Yeah, and before we sort of dive into this particular thing, just to expand on that a little bit, there are different things that defense attorneys try to do. One thing is they want their client to trust them. And one way to make your client trust you is to make it seem like you are fighting tooth and nail for your client. And a lot of times, I'll walk into a hearing, and you go into a hearing, a suppression hearing or various things. Usually, the client is in custody, so he's not there at the beginning. At some point, security brings him in. He's all shackled and everything, and they bring him up from a holding cell where he's waiting. And he sits down next to his defense attorney. Maybe they talk for a couple minutes, and they go. But the number of times that you walk into a hearing, the defense attorney's already there, and he walks over and says, "Hey, man, I know this is ridiculous. I totally get it, but my client wants me to do this, and, he doesn't really trust lawyers, so I'm doing the best I can to get him on my side." And you're like, "I totally understand. We'll fight it out. We'll see how it goes." That happens not infrequently. So there could be that. I think, looking at this case, it is such a solid case for the prosecution. The defense has to be thinking, save this guy's life. Idaho has the death penalty, and they now have multiple ways to execute it. And they may be thinking, I don't think he wants to plead, because I think this is all part of his psychology. He wants to go through with the trial. But I think if they can get him to trust them implicitly, and if they can make the prosecution so miserable with all their filings, and just sending a message of, hey, this is going to be hard, and we're going to make it a slog, and you guys are going to have to litigate every single point. We know there are 4 people murdered, but wouldn't it be better just to go ahead and take the death penalty off the table, plea this out, be done with it? We won't have to fight. We won't have to waste all these resources and all your time and all your money, and we can just take care of it. So it may be that there's a dual effort here. On one hand, to get the client totally trusting in the defense attorneys, and on the other hand, to sort of beat the prosecution down where they just want this to be over.
Yeah, that's a great point, Brett, because I've had both of those instances, and one particular defendant that I prosecuted is jumping to mind right now, where the client was never in a million years going to plead, and it was like a rock solid, can trace all the wires and their fingerprints are on everything sort of case. And they were absolutely guilty, but they were not going to plead, and they were going to go to trial. And every attorney they had, and I say every attorney because they had many attorneys, because that defendant kept firing attorneys because the defendant said that their attorney wasn't fighting for them. And really, the defendant's attorneys were looking at the case, and some lawyers have a higher bar for what type of filings they will file. And so some attorneys won't make those frivolous filings. You should never make a frivolous filing, by the way. It's kind of part of our code of ethics as attorneys. But there's different bars of what you determine to be frivolous or completely baseless. And this defendant just kept firing attorneys because, honestly, our case was so strong against this person that the defense didn't have much to go on, but she wanted to see someone pounding the table harder. And so by her 6th or 7th attorney, they were filing all these frivolous motions, and it was like the biggest headache ever. And it definitely took up a disproportionate amount of my time. And if she wanted to plead to something, I probably would have let her just to get her off of my desk, but she wouldn't plead. And so in essence, she took up all my time, and I think she enjoyed it that she took up all of my time because obviously I have a burden of proof I have to uphold, but if I was going to be charging her, then she in turn was going to make my life all about her, and she did.
Yeah. Sometimes prosecutors will say things like, some defendants are thinking, if I'm going to prison, you're going to prison with me. We're going to suffer together. And sometimes they make you do that. Okay, so what are we talking about here? So those of you who've been following this case, we're talking about the Idaho murders. I think everybody knows what that is, but just in case you don't, Bryan Kohberger has been arrested for the murder of 4 college students in Idaho, in Moscow, Idaho. Brutal murders, probably the beginnings of a serial killer had he not been caught. We have, in a previous episode, walked through the probable cause affidavit that was used for his arrest. There is some strong evidence in the form of cell phone information, sightings of a vehicle matching his description, and DNA that was found on a knife sheath, the sheath which matches the kind of knife that would have been used, and that knife sheath was found, I believe, in the bed or under one of the victims. I don't recall, and I'm not even sure if it's entirely clear, but very clearly part of this murder, and his DNA was found on that. Now, it seems clear, even though I don't know that it has been stated explicitly, that genetic genealogy was used in the very beginning of this case to take that DNA profile, which was not in any database, which is not surprising because the suspect has never committed any crime, so his DNA profile would not be in CODIS, for instance, was used to construct, through genetic genealogy, essentially a family tree to narrow this down and to eventually determine that a certain number of people this DNA could have come from. And then you take a look at that, and we've had, if you haven't listened to this before, Kristen Middleman, we've had her on from Othram. She was amazing. That was on our other podcast, The Prosecutors. She talked about genetic genealogy and how it works. And one of the things she said is you don't arrest somebody on the basis of genetic genealogy. What genetic genealogy is doing is it's giving you leads. And then you take those leads, and maybe you have, for instance, 4 brothers. And you can say, look, we're pretty sure this DNA came from one of these 4 brothers based on we have in our system the DNA of a 5th cousin. And from that, they work out sort of a tree where they can narrow it down to a certain pretty close family members. So you say you have 4 brothers, and say the murder was in Spokane, Washington. 3 of the brothers have never left New England. They've lived in New England their entire lives. One of the brothers lived in Spokane. Well, guess what? Now you have your suspect. And now, through traditional techniques, you can go find that person, investigate that person, hopefully get a DNA sample from that person, and compare it directly. And it seems like that's what happened here. You had Kohberger. They used genetic genealogy to sort of narrow it down to him. At some point, they did a direct DNA comparison, and his DNA matches the DNA on the knife sheath.
And I think that's incredibly key right there. There are 2 steps to that type of genetic matching. The first is to narrow the pool so you look at who your suspects are. You can do this with DNA. You can do this with cell phone records, for example. If you were to get a cell tower dump, what you're doing is you're not looking for one specific number. You're trying to narrow down because there's like infinite people you could be looking at. Narrow down the population you're looking at. And then when you have a good idea based on multiple other factors, such as location, such as car, such as, other sorts of information, then you directly go to who you believe to be the perpetrator and you confirm there. So it's not that the genealogy immediately maps you to it. It's kind of playing a game of narrowing down until you confirm it. And in this case, once you get arrested, you get DNA swabs, right? So if they did not have Kohberger's DNA before he was arrested, once you're arrested, they absolutely do have it.
And so now we're at a point where he has been arrested, he has been indicted by a grand jury, we are heading towards trial. The prosecution has provided a lot of discovery. The defense is requesting additional discovery, and included in that is discovery related to genetic genealogy. Now, there is a misconception out there, and we feed this a little bit because it's easy to talk about it as just the prosecution has a duty to disclose, and so you give everything to the defense. And we talk about open file discovery sometimes. Open file discovery is actually pretty rare because in any investigation, there is going to be a lot of information which is completely irrelevant. which when you actually get down to trial isn't going to be useful at all for the defense. Either it's not exculpatory, it's not inculpatory, it is sort of part of maybe the background of the investigation. Sometimes it's even stuff where the defense would fight tooth and nail to keep it out because they would say, hey, this isn't really relevant and it's duplicative. It's all those things. So we don't even want that to come in. And the prosecution sometimes will say, look, our obligation is to give you relevant evidence that's exculpatory or inculpatory, arguably either one. If it's not relevant, if it's not exculpatory, if it's not inculpatory, if we're not going to use it, we don't have a duty to give it to you. And the reason we're not going to give it to you is because we know you're good defense attorneys, and one of your jobs is to confuse the issue. We've talked about before that the best story wins. That is true to a certain extent. But sometimes, if you're the defense and you don't really have a story, what you have to do is make the prosecution story a bad one, a confusing one that really doesn't line up, one that really doesn't make sense. And the way you can do that sometimes is through distraction. It's introducing distracting things that don't really matter, but that make the jury confused or make the jury think a certain thing is important so that they'll have questions when they go back into deliberations. And sometimes when you're a prosecutor, part of avoiding that is you don't want to give the defense ammunition to distract with. You have to give them the relevant stuff, but you don't want to give them irrelevant stuff that, number one, you're going to have to fight with in front of a judge because you're going to try and keep it out after you've already given it to them. And number two, that if they do manage to get it in, they're going to use to confuse the jury.
Yeah, that's a really good point, because remember, there's all these resources and these are boundaries that we're drawing, right? Because in every single case, there's going to be an infinite number of things that you can talk about. We actually touch upon this in our other podcast, The Prosecutors, where we just finished a 14 episode series. By the time this comes out, that might not be the case. We have a 14 episode series on Adnan. And part of the thing that we're talking about within those 14 episodes, and why we tried to actually limit ourselves to 14 episodes, is that case has gotten so much attention because of kind of not relevant information that has expanded the scope of what people are discussing. And that's why there's a lot of parts of that case that become very confusing, because we're basically focusing on irrelevant information. When you have that before a jury, you have a real concern of confusing the jury or having the jury focus on an element or a fact that is not actually part of the charging document before them. And that's why it's the judge's responsibility to keep the relevant information in and the irrelevant information out.
And so when the prosecution goes to trial, one thing they're probably not going to talk about is genetic genealogy. They're going to talk about the actual DNA evidence that they've recovered and the actual DNA test they did on Brian Koberger, which matches the DNA. And frankly, that's all that matters. But that's not what the defense wants to talk about, because it's really hard to attack that. So they want to cycle back. They want to go back to before that, and they want to talk about genetic genealogy. And they have filed two filings which are relevant for us today. One is a motion to compel for the prosecution to release all the genetic genealogy information. And the other is an affidavit by someone who I guess has some familiarity with genetic genealogy. Alice knows all about her. And who has sort of raised concerns about the way genetic genealogy works in an effort to convince the court that this actually is information that could be relevant, that could be helpful to the defense, and that they should have to turn it over. The prosecution is pushing back on that. And before we get into why the defense wants it, we talked about one reason the prosecution's pushing back on it is a relevance thing. I also think the prosecution feels a little bit of an obligation to the genetic genealogy people. As we talked about when we talked to Kristen and Othram, they don't like to testify. That's not what they do. They're not the kind of people, they're not the kind of experts who typically testify in court. And testifying is hard, and it is a unique skill set. And experts who testify tend to be sort of a unique group of people. And oftentimes, people like Othram might even have to have experts on staff. If they're going to have to be testifying, they may need to bring people on who aren't doing so much the testing and the work in the lab, but just have to be there so they can go out and testify. And they don't want to testify. They don't feel like they should have to, because their job is just to give leads. It's not to actually provide actual evidence that will be used in trial. And I think the prosecution, probably being cognizant of that, doesn't want to just throw them under the bus and be like, okay, fine. You want to talk to our genetic genealogist? Talk to him. We don't care. It's fine. I think they're actually trying to protect them a little bit as well.
And that's a really great point, Brett, that I think a lot of the public doesn't recognize, is that becoming a testifying expert, especially in the medical field, becomes basically a full-time job. I did a lot of kind of bad doctor cases when I was prosecuting, and so we relied on a lot of medical experts who were doctors, and they were practicing doctors at some point. But some of them became such good experts, essentially. They testified for so many cases that they didn't have any time to actually be practicing anymore, because the process of writing expert reports, helping write rebuttal expert reports, testifying in court, prepping for all of the court cases and the testifying and sitting in, weeks, maybe months of trial, takes up all of their time, where they didn't actually have enough hours in a day to be able to leave open for practicing medicine. And so that's not always ideal, because you typically want your experts to also be practicing. But the reality is it's a totally different skill set, but also it's a completely different profession, really, to be a testifying expert, especially in the medical or scientific world, than it is to be the scientist who's running the tests, who's running the probabilities, and especially spitting out a medical report. And I can understand here why the prosecution doesn't want to release this information, because it was part of their investigative steps to get where they are. So when you release all the information that's relevant to your case, it's about that case. But remember, if we go all the way back to, say, a 911 call, there could be many leads that a prosecution goes down that leads to dead ends. They don't need to release all the irrelevant informations and irrelevant leads if that is not relevant for this particular case. So this is like, they probably took so many steps, and they don't have to release all of it because it's not part of the case file. It was part of the investigative rounds that they have to make. And there are probably a bunch of these other steps that they took that eventually led nowhere, that they don't have to release either.
And when you're thinking about this, when you're thinking through this, relevance is where it's at. Okay. So in order for evidence to be admissible, in order for evidence to be something that has to be turned over to the defense, it has to be relevant. It has to have some relevancy to the case. And relevancy in the law it's a very low bar, but it's a real bar. And it's basically, will the piece of information, does it have a tendency to either show some fact is true or some fact is not true? And is the fact, which it tends to show is either true or not true, related to the case in some substantive way? So, for instance, you have a car wreck case. We always go back to, is the light green or red? You might want to put on the weatherman. And the weatherman might talk about whether it was cloudy that day. If it's a nighttime case, whether there was a moon, whether there was a full moon. Whether it's cloudy, what does it have to do with a car wreck case? Well, it's relevant because it tends to show that maybe it's a little bit easier to see. Maybe it's a little bit easier to make out things. It's a little bit of the story surrounding the event that you're painting this story for the jury. You're trying to set out a theory that you have, and you're trying to provide evidence that supports that theory. So in the filing that was made, the initial filing before the affidavit came out, when Ann Taylor, who is the lawyer, she's laying out why she wants this information. And she says at one point, it is my understanding, and this is when she's saying, why is this relevant? Why do I need this? It is my understanding that once possible relatives have been identified, their identities are used to construct a family tree to identify possible suspects using public records, and in some cases contacting individuals for further family information. This process leads to a pool of individuals rather than one specific individual. The possibility of other relatives who might be similar to Mr. Koberger is extremely important to the defense in this case. The process used in this method of identification may be extremely important to Mr. Koberger's defense. The timing and steps utilized are extremely important to Mr. Koberger's case investigation and defense. And the question you have to ask yourself when someone makes assertions like that is, why? Why would any of that information actually be helpful in your defense? If it were just genetic genealogy, and that was what the prosecution was going to use, and they were going to say, look, we did genetic genealogy, and it has to be one of these 6 people, and he's one of them, so therefore, convict him. Okay, well then it's obvious. Makes sense. See why that's important. See why you need to know all those other people. Need to know whether or not they happened to be in Idaho at the time. Maybe they were murdering these people, and genetic genealogy points at the wrong guy. But the problem is, all of that information becomes irrelevant once you have the DNA evidence itself. The DNA evidence which provides a direct link. And there are a couple examples outside of the DNA world that you can think about where this comes up in cases where defense attorneys will often seek this kind of information and not get it. A good one is informants. So take a drug conspiracy. A lot of times, a drug conspiracy begins with an informant. So there's an informant who comes in and says, hey, I just bought drugs from X. And the police say, okay, now we could prosecute that. We could prosecute that one drug sale, and you could testify all about it and get up on the stand and tell that this happened, and we'd prosecute that guy. But usually the juice is not worth the squeeze on that. What you actually want is you want to figure out who all is involved in the drug conspiracy. Is the guy you bought the drugs from just a runner, or is he the main guy? Are there more people involved? Who's the source of supply? So what you can do is you can use the information that you got from that informant to do something like get wiretaps. And you put a wiretap on the person's phone that they bought the drugs from. Now you have a wire, and you're listening in, and you're finding out all this other information, all these other people who are involved. And eventually you bring a drug conspiracy case, and you base it on the wires. Well, one thing the defense attorneys are always going to do is they're going to ask for the existence of any informants and their identities. And there are a lot of reasons that you don't want to turn over the identities of informants. One reason is their safety. The other reason is because they're still useful to you. You don't want to burn them. You want them to give you more people. So a lot of times, defense will ask for it, will say the same thing they're saying in this Koberger case. We need to know everything about how this investigation started. We need to know who this is. The prosecution will respond, look, it's not relevant. We're not calling them. This is based on wires, not on informants. It's not based on that purchase. So this should not be turned over to the defense. And most times, 99 times out of 100, the judge will agree, and the defense will not get that information because at the end of the day, it's not actually relevant to the crime charged at hand.
And that's a really good point, right? Because a lot of people I know will ask, well, okay, what if the genetic genealogy or your informant in your example had it wrong? That it's not reliable. And so is there some sort of argument for a fruit of the poisonous tree where because your process of narrowing down was wrong, therefore your direct link, as you say, once you get the actual DNA swab that matches, is somehow fruit of the poisonous tree. And like in another case, you get to kick that out and no longer rely on that direct evidence, even though we know there's a direct match because you got there in a wrong way. Well, it doesn't really work here because just like the informant case, you don't go from the informant and directly charge a drug conspiracy. You get an affidavit and you go before a judge and get a wire. In this case, it wasn't just the genealogy that narrowed him down. It helped the police know where to look locationally for cell phone records, etc. You guys read the arrest warrant and you saw the prosecution lay out its many methods of narrowing down to Bryan Kohberger. It wasn't just because of genetics. The genetics was like the nail in the coffin, but there were the cell phone records. There was, eyewitness of his car being places. I mean, you can go back and read all of the different ways that they tied him and have him really dead to his rights and why they have such a strong case. So there's no fruit of the poisonous tree because it wasn't a violation of anything, no constitutional violation here. And also, guess what? You may or may not know this. You don't have a right to your DNA. You can be compelled to actually give your DNA whether or not you are arrested.
Yeah, and we're going to talk more about that later. Jason Blair sent us a very long email asking all about DNA, and there's a lot of interesting sort of legal questions about DNA. But Alice is 100% right. You don't actually have a right to that. And for the poisonous tree, remember, we talked about this with search warrants. What you're talking about here is, did a violation of your constitutional rights lead to the finding of evidence that is not admissible? Nobody's arguing there's a violation of Bryan Kohberger's constitutional rights here. Nobody's arguing that. Those of you who've been following this online will say things like, what if the police used a database that they're not supposed to use? So what? That's not Bryan Kohberger's rights being violated. Some people in that database might have some right to sue, but he can't assert their rights. He can't assert their privacy rights. So for instance, imagine you got a buddy and he's a law-abiding citizen, and you think, man, the police would never mess with him. I'm going to give him the gun that I used to commit this crime so he can keep it. And that way the police will never find it. And the police, for some reason, maybe they're executing a search warrant and they meant to do the house across the street, but unfortunately they kick the door in your buddy's house and they find this gun and they match it up to your murder and they realize, oh my goodness, this is the gun that was used in that murder. And then they arrest you and you file a motion to suppress and you say, you violated my friend's rights when you kicked down his door without a search warrant. Can't do it. You don't stand in the shoes of someone else. You have to have standing. You have to have a right to privacy that was violated. So even if everybody in America's rights were violated, in order to get Brian Kohberger's DNA, if his rights weren't violated, it does not matter.
And really, just to kind of close the circle there, let's say that the police got it wrong, or for some reason they charged the friend with accessory, with, whatever. That friend then has standing to challenge this and suppress the gun found in that search just for his case, though. And so all of this is about standing. And this makes sense, right? Because you can't just go out there and declare that you're going to vindicate everyone else's right when it does not affect you. Our justice system, the reason it's plaintiff versus defendant is because they are meant for the resolution of cases between two parties. It kind of extrapolating this out. This is why 404B exists. We've talked about 404B, where it is kind of other acts evidence. It doesn't have to do with this particular case. It's because our cases are meant to be about the controversy between the two parties for that particular matter. And for criminal cases, it's for what you are charged with. And so if you don't have standing to bring that particular violation, you're out of luck. And there's been no constitutional violation of Kohberger's. Let's be clear about that in this instance.
One of my coolest moments in law school, maybe in life, but definitely in law school. And this will tell you how much of a nerd I am. So it was like after my first semester, and I did criminal law my first semester in law school. My very first class was criminal law, taught by Alan Dershowitz. And he used to say, you're more likely to be a criminal defendant than a criminal defense attorney if you're in this class, which I always thought was funny. But I went home for Christmas break, and my parents were watching Law & Order. And it was a Law & Order episode where all the evidence was in this storage shed. But the police, when they filled out the search warrant, they put down the wrong address. And so in real life, that probably wouldn't matter. You probably get around that. But in the Law & Order episode, the fact that they put down the wrong address where they went into the storage unit was definitive. And so the evidence is all coming out. So they're trying to figure out what they're going to do. And then they get like this document and they give it to McCoy and he reads it and he looks up all shocked. And so the next scene, they're in court and McCoy's standing up and he's like, Your Honor, we have the rental agreement for the storage unit. And it's not in Mr. Defendant's name. It's in his sister's. And I was like, oh, and my parents are like, what? And the defense attorney's like, I don't understand why that would matter, Your Honor. The rights were still violated. And I was like, you can't assert someone else's rights. And sure enough, that's what it was. And all of a sudden, all the evidence comes in because it was in his sister's name and not his. And that's essentially what we're talking about here. If you can't show that your rights are violated, no dice. And in this case, it's not just you have to show your rights are violated, but all of this request for evidence, discovery, is all moving towards trial. If this were an attack on the arrest warrant, that would at least be one thing. Then you're at least saying, hey, this led to the arrest, so therefore maybe if we can undercut this, somehow the arrest is invalid and it actually wouldn't matter because now we have his DNA, just arrest him again. And so maybe you could do that. But remember, when we talk about the difference between trials and things like arrests, the standard is so much lower. It's probable cause. You don't need the DNA at all. And as a matter of fact, we even talked about this in one of our prior episodes, that in one affidavit, one of the police officers, he actually said in the affidavit, in addition to this information, we also have this DNA, but I actually don't even want you to consider that because on the off chance that there's some problem with this DNA, we don't want to have to litigate this later on, and we got plenty to rely on. And that's essentially what's happening here. Even if you knocked out the genetic genealogy altogether, the other stuff, the phone pings, the fact that his vehicle was cited there is enough. That's enough for a probable cause. It's enough to arrest him. So you're never going to knock out the arrest warrant. So really, you have to show why you need this information for trial. And given that it's not going to be fruit of the poisonous tree, it's not going to eliminate any evidence down the road, and you're not going to be able to get rid of that affidavit, the defense, in my mind, cannot show that this is relevant and that they should get it.
Yeah, that was a closing argument. Very good.
Thank you, Alice. Thank you, Alice. I appreciate that. And look, and I just want to address something Mike says. So Mike in the chat is saying he doesn't think the cops can just walk into a mall and ask anyone in the mall to give the DNA sample. They can't, because then they would be seizing you. And they do have to have probable cause to seize you. You have to show probable cause first. So, for instance, you can't just stop somebody on the side of the road without probable cause. You have to show that they did something. So you would have to get past the seizure point in order to do that. But if you have probable cause for an arrest, for instance, guess what? When you go in to the police station after you're arrested, they can take your fingerprints. They can take your DNA. They can make you give your name, even though all of those things might be incriminating. They can compel you to give them any of that stuff. The Supreme Court has basically drawn a line at blood draws. We're currently at where before they could draw your blood, but the Supreme Court has said blood draws are so invasive that you can't do that without a warrant or without consent. Where that becomes important is in vehicle accidents where it's obvious the person is probably drunk, but they're incapacitated. So you can't do a breathalyzer, you can't make them do any kind of DUI test. So you want to draw their blood at the hospital to test for their alcohol content. So, like I said, we're going to do a whole episode on the DNA stuff and when you can do it and when you can put it in a database and all that other stuff. That stuff is not actually that relevant for us now. This is DNA that he left voluntarily, as it were, on the knife sheath, and what you can do with that once you have it.
Yes. That was just a little teaser for a future episode. Well, that was one of the many filings, but we've already reached kind of our time for the day. I guess there's just going to be another episode for many more filings. But I hope this demystifies at least kind of what this filing is and why the defense is asking for a motion to compel. I think it's very telling that it's styled as a motion to compel and not a motion to attack, like you said, the arrest warrant, or even to ask for experts or to rebut their experts, right? Their expert, if you read the affidavit, it's very interesting. It's really not about Bryan Kohberger at all. It's about her experience in genealogy generally. And there's a lot of talk about how genealogy works and also kind of just phrases out there about potential things that could be problems with genealogy, not tied to this case. And again, not relevant because we don't have a problem with the genealogy. The genealogy did its job. It narrowed the pool, and then now we have the direct match. And that is incredibly important here. So the last couple of paragraphs of her affidavit state potential problems that she has seen in her career based on her profession. Perfectly fine. She doesn't make any attempt to tie it to this case because she can't.
Yeah, and let me just read you. I mean, in her affidavit, she also gives some other things the defense could use if they had this information. 1, compliance with Department of Justice policies. Guess what? Idaho doesn't have to follow Department of Justice policies.
And DOJ is not prosecuting him right now.
No, DOJ is not prosecuting him, and the policies from DOJ aren't binding anyways. They're not law. They're just policies basically meant to protect the privacy of innocent people. Completely irrelevant. That's the first thing. 2, how a DNA sample was handled from the time of collection through its forensic genetic genealogy testing. Completely irrelevant. Might be relevant to attack the direct DNA connection. The genetic genealogy part doesn't matter. All that matters is the DNA handling. Yeah, they should absolutely know how the DNA that was compared to CODIS was handled. And they will get that information if they don't already have that information. But it's not going to be relevant in trial. The process of SNP creation, once again, doesn't matter because what they're going to use at trial is the comparison between the DNA and on the knife sheath. The use of the SNP profile, once again, doesn't matter.
The last one is one we've been talking about this whole time. The use or lack thereof of loopholes and violations of terms of service to the various genetic genealogy databases. And previously she had talked about databases like 23andMe and other DNA ancestry trees. doesn't matter because Kohberger cannot assert any violations of privacy rights of those people within the databases. Basically, she's saying some databases don't allow forensic genealogy, and we don't know if the prosecution violated those agreements for the private companies, and maybe the people within that database have had their privacy violated. That's not Brian Kohberger's right to assert.
And look, if you think we're being hard on the defense or just being, showing our prosecutor bias by thinking everything that they file is stupid, I do want to talk briefly about their motion to dismiss, which, as Alice said, particularly when you're a defense attorney in criminal law, you can file whatever you want because no judge is ever going to find it frivolous because we want vigorous defense of a defense attorney. The motion to dismiss in this case is as close to sanctionable as any motion ever filed in a criminal case. If it were filed in a civil case, the judge would call the lawyer into court, lambast them, and then throw them in jail for a couple days to make them learn their lesson. It is absurd. The motion to dismiss is based on the idea that the 1880 Constitution for Idaho requires a grand jury to find beyond a reasonable doubt in order to indict, which even the motion itself admits has never been accepted in the entire history of Idaho. And for 140 years, just like in every state in the union and the federal government, the standard for the grand jury is probable cause, not beyond a reasonable doubt. It is absolutely frivolous and absurd, and I can't believe any attorney signed his name to that filing. And those are the kind of filings that we're getting from Brian Kohberger and his attorney, and we're going to see that until trial. But unless something changes, all I can say is I'm not impressed. And honestly, if I were the judge in this case and I saw that, nothing they filed from that point forward would I take seriously. I would be like, you better have a really good argument, because my assumption is every single thing you file is absurd.
Even though we haven't reached the jury here, it's the same judge who's going to be reading all this. So a vigorous defense, and it's hard. It is hard to draw this balance, especially when you have a case as strong as the prosecution has against Brian Kohberger in this case, to be vigorous without losing credibility with the court, because that still matters very much so. This judge is going to make all of the rulings leading up to trial, all of the pretrial motions, everything during trial, every objection that comes out of your mouth during court. And if this is going to be a long trial, if this goes to trial, every time you stand up and open your mouth, the judge has had a long history of dealing with you and your credibility up to that point. And it absolutely affects the judge and how they view every single thing that comes out of your mouth, because the judge at the end of the day really cares about the credibility of the attorneys before you, because the judge is going to do their own research and make sure they have the law right and everything. But if you are a respected attorney in a courtroom and the judge knows you, they know that they can trust you. They are going to trust but verify, absolutely, when they go back to their chambers and make sure the law that you're citing is correct. But you absolutely want to make sure you have that level of respect with the judge, that they want to recognize that you are going to give them the right law. You're going to give them good arguments, because remember, they're going to be held liable to the higher courts if there's an appeal. And if you're giving them bad law and you're giving them bad arguments and they rule for you, they're just going to be overturned and look stupid in the process. And the judge does not want to look stupid. And that's why it matters, your credibility before the court, because it doesn't matter. This judge can't just rule for the defense because they like them. If they're getting these terrible arguments, the judge is like, give me something better. Even if I wanted to rule for you, I can't, because I will be overturned immediately. And I will be overturned until I get it right. And so give me the right arguments.
This is such a good point that Alice makes, and it's worth spending a little time on. We have young people who are going to law school, or maybe they're just about to graduate from law school, and they always ask us, we get a lot of questions in the 5-star reviews. They ask us questions like, what is one piece of advice for you? And the point Alice is making is so important. Your credibility matters so much, because the law is really hard. It's actually really hard. If it were easy, anybody could do it. But figuring out what the law actually is, it's an adversarial system, but it's almost collaborative in some ways. Like sometimes you really are just all trying to figure out what actually is the answer here. And the defense is making the best argument they can, and you're making the best argument you can. And sometimes people think, well, yeah, they should be filing all these. This is a death penalty case, and they need to be representing him to their fullest ability, and they should be pushing every single argument. And Yeah, I can see why you would think that when you first look at it. But when you look deeper and you realize, no, there are going to be close questions where there really are two possible answers. And the judge is going to have to go one way or the other. And it's a tough question. And you get up there and you argue to the judge. And if you act like your argument has no holes, the judge is going to look at you and they're going to be like, ah. But if you get up there and say, look, you're right, Your Honor, we're weak on this point. Law is not great for us. We got some good law, but there's a lot more that's against us. We're probably going to lose on that point. But on this other point, which is equally important, really strong, and you really need to focus on that, not where we're weak. The judge is going to appreciate that because it makes his job a lot easier. And he's going to take your words and he's going to believe them more. And when he's having to make that really hard decision and choose between really good arguments from you and really good arguments from the other side, if you filed a motion to dismiss based on the fact that a grand jury should have to reach beyond a reasonable doubt, he's going to remember that. And he's going to say, I'm going to go with the other guys. And I just think it's really important to always maintain that credibility.
And since we're kind of in the vein of giving advice for, lawyers or soon to be lawyers, sometimes the situation does call for making an argument of first impression. One that hasn't been made before, is kind of far out. You're going to lose at the district court, but this is a matter that has to be basically ruled on by a higher court, maybe even the Supreme Court, the state Supreme Court, or the United States Supreme Court. How you make those sorts of arguments is you say, we recognize under the existing law, you can't find for us district court. However, we'd like to preserve this issue for appeal because, and then make your argument, right? There's a way to make an argument that you're going to lose by acknowledging you're going to lose and then recognizing that this isn't really a matter that the district court can even rule in favor of you for, but you're going to try your luck at the appeals process and see if you can get this, line of cases overturned, for example. So there is a way to kind of thread the needle in a way that maintains your credibility that we don't see in this motion to dismiss, by the way.
And it's hard because a lot of times you want to fight to the bitter end on every single thing. And that's human nature, particularly if you got a defendant you're trying to defend. It's a lot easier to give up things, I think, personally, when you're on the government side. But I think you have to be able to do it. And I think that is really the difference between, and it's a difference that the public never sees. The difference between a good lawyer and a great lawyer is knowing when to say, we lose on that point. That is our weakness. We concede that. And when you talk to judges, judges will say that. Judges will say that lawyers who get up in front of them and concede points where they're going to lose are the best lawyers and the ones that are most convincing. Because when they say, not going to concede this point, though, because we got a good argument, they sit up and listen. Because they know this lawyer, if it was a real loser, he would concede it. So that means there's at least a chance he's right here. And that's so important.
I mean, that absolutely comes with time. And that's kind of it's the judgment that sometimes you have it or you don't, but a lot of it comes with experience as well. And knowing the area of law and knowing how to react, because there's also a way to concede away your entire case. And you have to do so. You can't just get up and be like, we concede these important points. Because if you concede points that are too important, then you lose your whole case. So like we said, this is not an easy thing to do. We've now kind of veered off into how to be a great lawyer, but that will maybe be question and answer for another time. But I hope this helps clear up at least some of the filings that we're seeing here. And we don't say that lightly when we say that some of these filings are frivolous. And we're explaining to you why they're frivolous. We're not name calling in any way. Look, these lawyers, they are fighting to the death. And way to go, right? This is incredibly vigorous defense. He is getting the most vigorous, I think, defending lawyers I've ever seen. And he may be the driving force behind it. He absolutely might be. And that's also client management. You have to also know when to say no to your client or to say no in a way that preserves your credibility with the court. So we don't know what's driving all of this, but they are absolutely being vigorous. And we've explained why we think certain filings are frivolous, and it is not meant to name call anybody.
So Alice, we now have legal brief questions. So if you want to answer a legal brief, as we've said before, if you leave a 5-star review and put a question in there, we will answer the question for you in a live show. So some of you have started taking us up on that for legal briefs. So we have a question, and this sort of fits with what we've been talking about. It is from Louder Voice, and it says, I'm in my mid-30s and thinking of going to law school. Is it worth it at my age?
Whoa, I don't think mid-30s is old, first of all.
Yeah, number one, mid-30s is not old. Number two,
spring chicken there.
Age of all the possible elements to consider is probably the least important one. There may be all sorts of reasons you shouldn't go to law school, but I don't think age is the one.
I totally agree with that, because I think the one thing that I always tell people applying to law school is if you can afford it, take some time off. No matter how old you are, basically. In your mid-30s, you've probably had enough career and life experience that works out well. And this is why. What we just talked about, judgment, knowing when to concede certain points, knowing what is a big deal and what's a small deal. These things happen over time as you gain experience in worldly things, not necessarily just within the law. And so I think life experiences over time always make you a better lawyer. And so going to law school in your mid-30s probably prepares you for law school much better than, you know, someone who scored a perfect 180 on their LSAT, the entrance exam, for example. And I had several people in my law school class who were second career lawyers. So, you know, I had a friend, one of my good friends in law school was a violin bow maker. He was a violin maker and a violin bow maker. And he'd been doing that for, you know, more than a decade before he decided to go to law school, also in his mid-30s. And he's like one of the best lawyers I know, because honestly, he had such insight into how the world worked in ways that I didn't when I was 22, graduating from college and going to law school. So don't let age be a factor, but some things to think about. What are your opportunity costs? Your opportunity costs in your mid-30s, personally, in terms of your family, in terms of cost, in terms of saving for retirement, those sorts of things absolutely should be part of your calculus, because law school is very expensive. Unlike PhD programs, very few people, very few schools will be offering big scholarships, because everyone just assumes lawyers will have the ability to pay off their loans. But really, it's only if you go to the private sector. So think about those things, because I think those are real costs you have to weigh, but don't make it be because of your age.
And I'll just say a couple things about this. And cost is so important because law school is expensive. In law school, unlike college, a lot of times college, you know, if you go to the right school, if you go to an in-state college, if you can get a scholarship, if you do it right, a lot of people can do college for a pretty low amount. Law school is almost never like that. It's not that there are no scholarships in law school, but law schools are, man, they're all about making money. They really are. And it is seen as, you know, college in some ways has become this, it used to be about making money and sort of you needed it for certain jobs, but now it's kind of like we all want to expand our horizons and do college and like live the college experience. And so there's this sort of feeling that, you know, it's more sort of broad based. But law school is very much still a trade school. At the end of the day, it's a trade school. It's like going to any other trade school. The expectation is you're going here, you're going to pay a lot of money because you're going to make a lot of money and you can pay it back. And that's the way to think about it. But if you go to law school, you're going to have a lot of debt. And when you graduate from law school, legal jobs actually can be pretty hard to get. Some jobs you really can only get if you go to the very best law schools. Obviously, if you go to law school, you graduate, and you pass the bar, which is also important, you can always hang out your own shingle and sort of start your own law firm, but that's tough. So it's think about it a lot when you think about going to law school.
And that's a really good point that I don't think enough people tell potential law students, is the part about getting a legal job. Getting a legal job is difficult because law schools are in the business of making money. By the way, we're saying things that law schools don't want you to know. They are in the business of making money. And guess what? When you have a good that you're selling and you make money off of it, what do? You sell more of it. You open more seats in your classes. That's why there are so many lawyers who graduate every year who can't find law jobs, because the supply is so much greater than the demand for jobs. We have way more lawyers than we have positions for legal jobs, and legal jobs that pay well enough, honestly, to pay back your loans for law school if you're borrowing money. Whereas like in other professions, just about every other profession, that's not how it works, right? I don't think we have enough doctors, for example. We have, many positions in the medical field.
We got way too many lawyers, though.
We have way too many lawyers. And that's really, really difficult, because you have law schools, you have law school rankings, and then you have like even unaccredited law schools where you can go to law school. You may or may not pass the bar because they may or may not prepare you for it, or certain jobs require you to go to an accredited law school that you may not have known when you chose that law school, because maybe that law school afforded you the opportunity to take classes online or something like that. Some flexibility that was great for your stage of life, but you weren't thinking ahead to when you had to find a job that would help you pay back the loans to go to that law school. And then you realize, oh, I needed to go to an accredited law school in order to be barred in this state to practice law. So all this is to say is be critical about law. Someone will take you. I will say that much. If you want to go to law school, you can go to law school. Is it going to be an accredited law school or a law school that will prepare you to be able to get a legal job that allows you to pay back your loans? Maybe not. But if you want to go to law school, anyone can be a lawyer. And that's honestly why when people are like, oh, it's so great you're a lawyer, I'm like, no. Anyone can be a lawyer. I promise. To be a great lawyer is something else.
So I'll make 2 points and tell one story, because I always have a story. The first point I would make is there's nothing wrong with taking the LSAT and seeing how you do. You know, if you're thinking about going to law school, yeah, like Alice, look, get yourself a book, take a few practice LSATs, see how you do. Go take the real one, see how you do. If you do really well, then, you know, I mean, if you can get into any law school in the country or into a really good law school or into the best law school in your state, paying for it's not going to be so much of a problem. Because once you graduate from that law school, you will get a job and you'll be able to get a job anywhere you want. And so I think that's important. Do that. Try it out. See whether it works. And weirdly, a lot of standardized tests are kind of gobbledygook, but there have been a lot of studies that how you do on the LSAT actually is pretty consistent with how you're going to do in law school. I don't know why that is. So if you do really well on the LSAT, you'll probably do well in law school, and then you'll probably get a really good job. And so the money is not so important. I just don't want anybody to go out there and get into debt to do this. The second thing, if you go to law school as an older adult, 30s, not that old, a lot of the people that I knew who were older, I went straight through, wish I hadn't. I wish I'd take some time off. Though I wouldn't change anything because I like where I'm at. But nevertheless, they treated it like a job, and I think you would too. So for those of us who went straight through, we treated it like it was an extension of college, right? They got up in the morning like they were going to job. They did their readings. They went to class. They did more readings and studying. They went to class. And then around 5 o'clock, they were done, just like it was a job. And then they went home to their families and did their family things. And so law school for them was a job. And frankly, they did a lot better in it. They were very successful. If you go back in your 30s, I think you're naturally going to do it that way. But that is a really good way to do it. And you should do that. So those are my two points to make. And in my story, when I was in law school, I knew a guy who was in his mid-40s who was in law school. He actually was late 40s because he had been a surgeon, so he'd been a doctor, but he loved the cocaine too much, and he lost his medical license, and so he decided, well, I can't be a doctor anymore, so I guess I'll be a lawyer, and he went to law school.
We had several former doctors in our class. So what I think that tells you is that if the medical field is too hard for you, come on over and be a lawyer, because apparently it's way easier.
Or if you've done something in the past that would keep you from doing some other job, law
right?
school's
Wouldn't
the
that
way
cocaine
to go.
keep him from getting through the ethics portion of the bar?
There, you can get to the ethics. Unless you're currently doing something illegal, you can get to the ethics portion.
Oh my goodness. Well, that was a good question, and we spoke way too long about that.
Well, that's all I got, Alice. It's been fun as always.
It has been so fun, and we love doing these lives. We'll try to continue to do them as well. Thank you guys for all your support on both Legal Briefs and the prosecutors. And now we are getting really close to CrimeCon, and Brett and I are both really excited. We will be at CrimeCon. We hope to see you guys there. And in fact, I ordered us a tablecloth this year so that people can find us, because apparently people couldn't find us because we just had white tablecloths.
We need to get ourselves a little whiteboard too that'll say when we're there, because one of the big complaints last time is that we were never there and people would come by. So we should be able to say,
go to the
back
bathroom,
in
guys.
20 minutes or whatever. Yeah.
Okay, we'll bring a whiteboard. We can do that. But we are so excited. We hope to see a lot of you guys there. And thank you for these questions. Don't forget to let us know what you think about this episode. Also, especially on Legal Briefs, let us know what you want to hear about. We love explaining different legal concepts or what's happening in, true crime legal news for you. But this is all listener driven. So write to us at prosecutorspod@gmail.com or find us on Facebook, Instagram, Twitter. Are we anywhere else?
We're on Threads now that we've never posted.
And Threads at Prosecutors Pod. And you can message us your recommendations. We would love that. And really, until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs.
Sorry.
I could see you weren't ready.
No, I was ready. When I was getting ready to click on it, I clicked out of it accidentally.
Oh my gosh.
So, anyway.
Okay, I have to think. How was your day? What day is today? What day?
Today is Wednesday.
I have no concept of time.
Wednesday.
Wednesday. A Wednesday.
I also think it's weird that, like, I guess in Idaho, the lawyers fill out affidavits to support their motions. It's like,
so
why don't
I've
they
had
just
to do
file
that
a
in a
motion?
couple states. No,
Yeah.